Welcome, everybody. Welcome to another Law of Self-Defense live show. For those who may not know, I am, of course, attorney Andrew Branca for Law of Self-Defense. Welcome. Come on in. Make yourselves comfortable. Let me switch over to the comments here. See what might have been popped up that I need to know. I know there's a few questions here from people who are waiting on books, Law of Self-Defense books that they've ordered, which, of course, I don't. Well, you may have ordered the hardcover or the soft cover. The soft cover is what we call our free book. Of course, it costs us money, but we provide it to you for free at the cost of shipping and handling. You can get that at lawofselfdefense.com/free book. Simple enough. We are fulfilling back orders. So we're probably still 2 or 3 weeks behind. Sorry, you folks ordered a lot of books at the end of last year, and we're catching up, but they are on their way. That's the soft covers. If you ordered a hardcover, we still have those in inventory, but they're not free. You have to pay for those. But if you're interested, you can get those at lawselfdefense.com/get-hard for the hard copy of the book. But if you placed your order, got your confirmation on the soft covers of the free books, they are on their way. We're having them printed up and shipped out as rapidly as we can. By the thousands, folks. It just takes time to get some of this stuff done, especially in these days of Brandon's supply crisis shortages. My apologies for that, but there's not much else I can do about it. So I also see this questions here about Edgecombe, the Edgecombe trial in Wisconsin. I do plan to be covering that. If Nick switches over to Edgecombe, that's his call to make, obviously. I'll probably just join him for his stream after I do my own live show here in the morning. I'm not really interested in competing with Nick to cover the same cases. We work pretty well together, and I'd prefer to do that. If he stays on that other case, the Halcombe case, the guy who chopped up and killed his family, I'm not interested in that case because it's not a use of force case. So we'll just have to see what happens there. So throughout the course of today's show, as always, if you'd like to ask questions in the comments that will get answered, guaranteed to be answered, either about the subject matter we're talking about, which is representing yourself in court, being your own lawyer, by the way, even if you are a lawyer, and also kind of a cautionary tale about relying on the apparent plain English reading of statutory language to understand the law. Very, very dangerous. We have a real life example of that as well to share with you today. So as we go through the content, if you'd like to ask questions, guaranteed they get answered, or if you'd like to ask questions about anything else, use of force law related, we're happy, we promise to answer all those questions. We do, however, have to limit ourselves to answering the super chat. Sorry, folks. We do, however, have to limit ourselves to answering the super chat questions because otherwise there's just way too many to cover in a reasonable period of time, which is unfortunately all any of us has really is a reasonable period of time. And of course, as always, I caution, I'm a boomer, and so these fancy technology things like live streaming, sharing screens and such are still a little bit of a mystery to me. Please, well, you'll either be patient or you want. I suppose my please doesn't have much to do about it, but we do our very best to make this as efficient a process as possible. So I really have two kind of case examples I want to share with you all today. One involves a gentleman in Missouri who's decided to be his own attorney in a reckless endangerment case. It's only a misdemeanor case, so arguably not that big a deal if he gets convicted, and certainly based on what I see of his defense, he's likely to get convicted. He doesn't really know what he's doing at all, which is not a good place to be in a criminal defense. But we'll talk about that, and we'll also talk about a question that came into our office about someone, a law self-defense member, very smart guy, but who overly relied on, excuse me, on a representation of use of force law made to him in a CCW course by trained and certified use of force experts, right? Instructors, trainers. They got to the state portion or the law portion of their CCW course. They showed him, this law self-defense member, the actual statutory language on a particular issue. It happens to be defense of others. And they said, this is the legal standard for defense of others. It's right there in the statute, plain English reading of the statute. That's the law. And this member contacted me because he said, well, Andrew, you told us the law was something different. And here I am looking at the statute, and it says the opposite of what you said. So who's right? Well, the answer to that question, as I'm happy to tell you, is it's almost always me. And it is me in this instance. And that's a case example that I'll walk all of you through on why it's so dangerous to rely on the apparent plain English reading of a statute, because it can be effectively a misstatement of the law. And I know that sounds impossible to believe. How could the statute be wrong? It can. And we'll talk about that in more detail. So the first case I want to talk about comes out of Wyoming. It involves someone who's this. First of all, I find the whole situation very suspicious. So I'm pretending for purposes of education and entertainment that this is a genuine story out of Wyoming. I have to say, normally I would share with all of you the URL for this news story in scare quotes. But the website appears very sketchy. It collapses all the time. You can't copy and paste things. So frankly, it made me quite nervous. So I'm not going to share the URL because I think there's something sketchy about it. As I will share screen captures of the content of the news story. And I imagine if you Google the names of the people involved in the news story, you'll come up with the original source I had. But I'm going to make you find it yourself. It won't be that hard. But I'm averse to providing a URL to something that's broken or doesn't smell quite right. So what I'm going to be sharing with you are screen captures of that news story. And it's possible the news story is a complete fabrication. Who knows? But like any use of force event described in the news, they're almost always wrong. Almost always. They must be assumed to be wrong until proven otherwise. I almost never see the media get use of force coverage correct. But despite being wrong, they can be useful training opportunities for us, because we can just pretend they're wrong, like they were a hypothetical use of force example presented on a law school exam, and we can apply the law as we understand it to the facts of that hypothetical and develop a better understanding of how the law should apply. So whether this news story is real or whether it's some weird, who knows, doesn't really matter for our purposes. It's a learning opportunity for us. So the first screen capture I'm going to pop up, which means I have to do the share screen thing. So let's see if I can pull that off, is share screen. And here's the screen, and let's see how that works. Okay, hopefully that's more or less legible for everybody. Let me see if I don't know if I can make it any bigger. Okay, that should be big enough for people to read. So purportedly, this story involves a gentleman called Joey Correnti IV. So 4 Joey Correntis in a row. That's, or at least in sequence. That's rather remarkable. He lives in Wyoming. He's reported here as the Carbon County's Republican Party chairman, defending himself from a charge of reckless endangerment stemming from allegations he pointed a pistol at a man after the man hit him. So one thing I want to note up front is this news story comes across as complete propaganda, because it presents a false representation of the facts from the very first sentence and in the first few paragraphs. So from this, we're supposed to believe that someone hit him, he pointed a gun at someone, and because he pointed the gun at someone, he got charged with reckless endangerment. In fact, he did more than that. But they want you to enter the story. They want to frame your understanding of what happened here along these lines. Merely for pointing a gun at someone, he was charged with reckless endangerment. And as we'll see in a moment, Wyoming has a statutory provision that explicitly says merely pointing a gun at someone is not reckless endangerment if certain conditions have been met, which of what this guy is going to try to argue should relieve him of criminal liability on this charge of reckless endangerment. Hey, there's a statute that says pointing a gun at someone who's attacked you cannot be reckless endangerment. It's excluded, merely pointing a gun. So this charge should be dismissed. What you don't find out until several paragraphs into the story is that he did more than point the gun. So let's continue. Joey Correnti IV is asking that the charge against him in connection with this October incident be dismissed because his actions after being hit by Nicholas Chadwick, I guess the guy who hit him, were in keeping with Wyoming's Stand Your Ground law. Now, there is no law in Wyoming called Stand Your Ground. There's a kind of wishy-washy self-defense statute, not very well constructed self-defense statute in Wyoming, which until very recently was actually only a defense of highly defensible property statute. Then Wyoming had been a duty to retreat state, decided to become a stand your ground state. And I'll give you the effective date of that for those who are interested when we get to that statute. And instead of creating a separate individual statute that said you don't have a legal duty to retreat if you're otherwise acting in lawful self-defense, they decided to stick that language into the defense of property statute, which is not a great way to do things, folks. So we end up with a very lengthy, what was a defense of highly defensible property statute, well focused on defense of highly defensible property, by the way. That was well structured. And they larded it up with good law, but law that should have been put in an independent statutory provision. So it had its own statute number, just to avoid confusion and provide clarity. But in any case, even that law is not actually called Wyoming's Stand Your Ground law. It just has Stand Your Ground language in it, among a lot of other language. Here's the bad part in particular. Correnti is serving as his own attorney in the action. He told Cowboy State Daily, which is the purported news agency reporting this story, because the law allowing the use of force in self-defense is clearly written. Well, one might argue it's clearly written once we look at it. It's not that clearly written. I could have written it more clearly, but to the extent it's clearly written, it doesn't exempt him from what he actually did, which is unfortunate because that means his purported legal defense is not a defense at all. Then we get to this part, which I particularly like, purportedly quoting Correnti. I know the old law saying that anyone who would defend themselves in court would have a fool for a client. But because of the strength and clarity of the Stand Your Ground law, again, there is no Stand Your Ground statute. There is no Stand Your Ground law per se. I think even a fool would have a legitimate shot at having this case dismissed, he said. It's the most common thing you hear, folks, when people decide to represent themselves in court or do anything else stupid. They say, well, I understand. Normally, someone representing themselves in court, they're a fool. We all know that, cliche. But in my case, I'm so smart, or the law is so clear, or this is such an open and shut case that for me, it's different. It's not different, folks. You're still a fool for representing yourself in court. People always have these excuses for doing things stupid. I know normally drunk driving, they'll say is, that's stupid. You shouldn't do that. But for me, I mean, I'm such a good driver. I'll be fine. Don't worry about it. I know pumping gas while smoking a cigarette is normally a stupid thing to do. But, I mean, for me, it's different. I mean, nothing bad will happen to me because I'll do it responsibly. Or I know juggling chainsaws on a unicycle is normally dangerous. But hey, sure, I've never done it before, but I've always been a good athlete in my family, and I'm sure it won't be a problem. Once you hear that but, folks, that should be the end of the discussion. And for people wondering if, heaven forbid, I were ever involved in the use of force event, would I represent myself? The answer is absolutely not. No question about it. Now, would I be heavily involved in my defense behind the scenes? Of course. This is an area of expertise for me. But I would not be the person arguing the legal arguments in front of a judge or a jury. I would hire competent legal counsel to do that. Unfortunately, I'm in a position to know competent legal counsel. But I would not be defending myself because you get too emotionally bound up in what's happening. And your ability to engage in effective critical thinking diminishes. And by the way, folks, we see this all the time, just in general, right? So when I say a diminishment in the ability to engage in critical thinking, that doesn't make the person who's doing that a bad person. It makes them a normal person. Normal people don't actually engage in much critical thinking because normally they don't need to. Normally their life does not demand it. Their career is not dependent on it. Most of us go through life in the normal way, awash in biases and misperceptions and preferences and blindness to things that we don't want to believe are true. And that doesn't make us bad people. That makes us normal people. One of the things that's different about being someone like an attorney, or arguably someone, I should say, a good attorney, because not all attorneys are good critical thinkers, unfortunately, but also being a good objective investigator or detective, or for that matter, a really good diagnostic physician, is the ability to objectively look at all the evidence, all the facts, even the stuff that you don't like, even the stuff that makes you uncomfortable, even the stuff you wish was not there. In my case, even the stuff that's harmful to my client's legal position or my personal political preferences or whatever the case might be. But consider all that objectively from all perspectives. Think about the argument I would like to foster and think about the argument I'll need to overcome that the other side is going to advance. That's what critical thinking is all about. And normally people don't do that. They think they're doing it. Everybody wants to think they're doing it. But if you see them frame their arguments, it's common, routine to see that, well, they're just ignoring the evidence they don't like, or they're ignoring the law they don't like, or they're pretending that their interpretation of the law is the correct one, even though when it's demonstrably incorrect, if only they had bothered or cared to look. So it's very common when people are about to engage in something stupid, they know it's stupid for everyone else, and then they say, but, and they carve out an exemption for themselves. Once you hear that but, that should be the end of it, folks. So please, if you are going to rely on your own interpretation of the law, you need to do it in a really well-informed way, which, at least in the use of force law context, is one of the missions here at Law of Self-Defense, is to put you in a position to do that. Not necessarily to be your own lawyer. You should not be your own lawyer, but you should be a super well-informed consumer of the legal services of any use of force lawyer that you would retain should you, unfortunately, be involved in an unavoidable use of force event. So what's this reckless endangerment charge all about that this dude is facing, this dude who's decided to, be the fool that represents himself for a client? The charges, quoting here again, filed in December, stem from allegations that during an altercation in Saratoga in October, Correnti, the defendant here, aimed his 9mm pistol at Chadwick after Chadwick hit Correnti in the head. Okay, well, let's assume, for argument's sake, that this pointing of the gun was appropriate. So a blow to the head, could be a dangerous blow by itself, probably not deadly force unless there's some aggravating factor, but it might be an indication of a pretty good indication that you are going to get punched again is that you got punched the first time. So to forestall the probability that the beating will continue, assuming that this Chadwick fellow was in a position to continue the beating, pointing of the gun may be a justified defensive display, depending on facts and circumstances not shared here, especially if there was a disparity in age or strength or size or fighting ability. All that would come into play. So we can't really make an informed assessment of that. But for purposes of discussion here, let's assume that the pointing of the pistol at the thrower of the punch to the head was an appropriate defensive response by Mr. Correnti. Certainly that would seem sympathetic to him. And now he's charged with reckless endangerment just for that? How could that be? And then it gets even more sympathetic for Correnti. According to a police report from the incident, Correnti was helping a woman move into a home when Chadwick, the woman's husband, a rut-row, I'm going to pause right there. So now we find out that Correnti has actually inserted himself in a domestic situation. Again, at Law of Self-Defense, we don't tell you what to do. If you want to insert yourself in other people's domestic problems, that's up to you. You make that choice. We just try to help you make an informed choice. And it's difficult to imagine really a more dangerous use of force situation to put yourself in than in the midst of a domestic situation where you may well find the partner in that domestic situation who you thought you were helping ultimately decides to testify against you in court over your use of force decision-making, perceptions, and actions. That's not a great place to be, folks. When the person you were helping or rescuing, or however you want to think about it, is telling the police and prosecutors, judge, and jurors that you were the problem, does it really matter if it's true or not? Or does it just matter that that's the compelling narrative that those other parties who were not there are being told by the person who was incontestably the victim in this situation, right? So anyway, he decided to insert himself in a domestic situation and bad things happened. Where's that William Shatner shocked expression? Can't believe it. Bad things happened. Particularly the woman's husband arrived. This would be Chadwick. The woman's husband arrived and confronted the woman and alleged that she was in a relationship with Correnti. Again, does it matter if that's true or not? Let's pretend it's not true. What matters from a practical perspective is whether that Chadwick fellow believes it's true and is willing to resort to physical violence in outrage over what they perceive to be a true statement, because then you're in a fight, right? It's not up to you whether you're in the fight. It's up to this Chadwick fellow whether you're in a fight. The report said that Chadwick tried 3 times to grab the woman's phone, grabbing her wrist at one point. Okay, let's assume that's true as well. The story continues. And by the way, that would be, of course, a simple battery, aggravated by the fact that it's a domestic. So Chadwick's engaged in unlawful conduct here. No question about it. Let's see. So the report said Chadwick tried 3 times to grab the woman's phone, grabbing her wrist at one point. Correnti inserted himself between the woman and Chadwick, the report said, and the two argued briefly before Chadwick hit Correnti near the right temple. Anyone shocked that this happened at this point? This surprise anybody? Not saying it's lawful, but would a prudent person have predicted that they had a good possibility of getting punched in the face if they inserted themselves between a wife and the husband in a bad relationship position where the husband believes the person inserting themselves is the wife's new lover? So he got hit near the right temple, punched in the head, and Correnti then brandished a pistol. So, of course, brandishing is a legal term of art that, unfortunately, with a very ambiguous legal definition, largely subjective decision that's going to be made by other parties, third parties. What qualifies as one person's defensive display is another person's brandishing, is another person's aggravated assault with a deadly weapon, a felony good for 10 to 20 years in prison. So very dangerous terrain. You can start waving that gun around, and maybe the authorities will decide that's not criminal conduct at all. And maybe they'll decide it's a felony good for 20 years in prison. And is that up to you? Nope. So I urge great caution before you put yourself in a position where you could be made to look as if you were unlawfully waving a gun around, because it can look very, very bad. So here we go. Correnti then brandished a pistol, pointing it at Chadwick, telling Chadwick not to hit him again or he would put Chadwick down. Okay, so let's again presume that this would be lawful, that the punch in the head, there's some aggravating factors that suggest that could be the precursor to a deadly force attack, meaning an attack capable of inflicting either death or great bodily harm, serious physical injury. However, whatever 3-word phrase Wyoming happens to use to define that, every state has a 3-word phrase that means something more than minor injury. If it would be a deadly force attack, then certainly, or to deter an ongoing deadly force attack, let's presume that pointing the gun at Chadwick, telling him not to hit him again or he would put Chadwick down, let's presume that's all good. And to this point in this news story, that's all we've been told happened, is merely pointing of the gun. But that's not all that happened, is it? Nope. Because we also learned that after Correnti fired a shot in the air, Chadwick left the scene. So we're not just pointing a gun. Now we're firing bullets into the air. Well, those bullets don't go on an interstellar travel, folks. Those bullets land somewhere. And if you're in anything like a populated area, you fire that bullet, bullets don't miss. They continue to move until they hit something. And if they hit a person, they could kill that person. So you've endangered that person. Now, whether the endangerment is reckless would depend on whether it was unjustified and whether you were consciously aware of the risk and consciously disregarded the risk. Well, firing a warning shot is a deliberate act. You're firing a round into the air You know you have a gun in your hand. You know you're firing a bullet. So that was a conscious discharge of a firearm. It was not a mistake, as in the Kim Potter case, where she believed she had a taser in her hand. And you have to know, any reasonable person would know, that the bullet's going to keep going till it hits something. And if it hits a person, it could kill them. So you're consciously disregarding that risk by firing the warning shot. And of course, it would have to be unjustified. But where pointing of a gun might be justified, that doesn't mean that firing of the gun would be justified. In fact, the very fact here that the shot was fired not at Chadwick, the assaulter, but merely into the air suggests that even the defender did not believe he would have been justified in firing the shot into Chadwick. To put it another way, if he believed he was legitimately facing an imminent deadly force threat from Chadwick that could not be otherwise be avoided, which would appear to be the only rationale here I can see for firing the gun, he would have fired the gun into Chadwick, not into the air. Firing the gun into the air doesn't do anything to compel Chadwick to stop attacking him. So this kind of warning shot scenario, very, very common to see it result in reckless endangerment charges, folks. Very common, increasingly. Because again, unless you're out in the ocean or in the Great Plains or somewhere where there's literally not people around for 5 miles or so, you are endangering innocent life in the area by firing that shot into the air. So it wasn't the pointing of the gun that got him charged with reckless endangerment. It was the firing of the shot into the air that got him charged with reckless endangerment. And somewhat shockingly, to tell you the truth, in Wyoming, this is still only a misdemeanor. In most states, reckless endangerment, where you're creating an unjustified, conscious risk of death to innocents, it's a felony. It's not merely a misdemeanor. In any case, Chadwick pleaded not guilty to a charge of criminal battery. Chadwick being the guy who threw the punch. And by the way, he might have an argument there, right? He may be not guilty on the grounds of self-defense. He may be prepared to argue that Correnti did something to threaten him, and he responded in self-defense with the punch. We don't know. We weren't there. We would have to hear that story. In any case, the criminal battery, normally simple battery, is merely a misdemeanor. His case is pending. And then in December, the following month, Correnti was charged with reckless endangering, also a misdemeanor. He pled not guilty. And he's asking that the charge against him be dismissed, in part because state law describes the act of pointing at another person as a crime unless reasonably necessary in defense of his person, property, or abode, or to prevent serious bodily injury to another, as provided by the Stand Your Ground law. So first of all, this is not a provision of the Stand Your Ground law. There is no Stand Your Ground law, but the statute to which Stand Your Ground language was added a couple of years ago that made Wyoming a Stand Your Ground state, that statute is not the statute that has this language in it. This language was embedded specifically in the reckless endangerment statute of Wyoming. And I'm sure it was an amendment to the statute to address precisely the situation where someone is making what they think was a defensive display, that they're merely pointing the gun at an aggressor, and the legislature decided, well, that should not be a crime. That should be excluded from the definition of reckless endangerment. But it's the mere pointing of the gun. It's not the discharge of the gun. So we can look at the actual statute. Let me see if I can pull that up here for you. I'm not sure what's going to happen when I click some of these buttons, so let me pause that. So here is the reckless endangerment statute. Here we go. Oh, I know the font is small, folks. Let me see if I can make that a little bigger for all of you. So this is Wyoming Statute 62504, reckless endangering. The penalty. A person is guilty of, see if I can highlight that for you, of recklessly endangering if he recklessly engages in conduct which places another person in danger of death or serious bodily injury. Okay, fair enough. Paragraph B, any person who knowingly points a firearm at or in the direction of another, whether or not the person believes the firearm is loaded, is guilty of reckless endangering. So pointing a gun at someone is reckless endangering unless reasonably necessary in defense of his person, property, or abode, or to prevent serious bodily injury. There's that 3-word phrase, serious bodily injury to another, or as provided for under Wisconsin Statute 62602, which is their self-defense statute. I'll share that with you in a moment as well. Reckless endangering is a misdemeanor punishable for not more than 1 year in prison. That's the entirety of the statute, and you'll notice it has nothing to do with stand your ground. Doesn't say anything about the element of avoidance. Doesn't say anything about a duty to retreat or the absence of a duty to retreat or conditions on qualifying for being relieved of a duty to retreat. It has nothing to do with stand your ground. So this claim by Correnti that this language is provided for in the stand your ground law is simply wrong and a reflection of the fact that he's not an attorney. He doesn't actually understand these legal provisions and why he's a fool for representing himself in court. Now, it does say, of course, that, as we just noted, that you're excluded from reckless endangerment for pointing a gun at someone if you did so in reasonably necessary defense of your person, property, or abode. So the pointing of the gun here might be an exclusion from a reckless endangerment charge. But Correnti did not merely point the gun. He's not charged with reckless endangerment for pointing a gun. You think the prosecution doesn't know this is a carve-out of reckless endangerment? He's charged with reckless endangerment because he did more than merely point the gun, because he actually fired the gun. That's why he's facing that charge. So the fact that this exclusion, this carve-out from reckless endangerment exists is pointless for this defendant because of his actual discharge of the gun. So let's get back to the story. Whoops. The stand your ground law, again, there is no stand your ground law per se. It's just language added to the defense of highly defensible property statute. We'll go over that in just a moment. But the stand your ground law allows the use of force in self-defense when a reasonable person believes it's needed to prevent an injury, loss, or imminent death. No, that's not really what it does. That's what self-defense law does, is allow for the use of force in self-defense when you reasonably believe it's necessary to prevent an injury, loss, or imminent death. This is poorly framed, but that's self-defense law is simply the privilege to use force to prevent an imminent unlawful use of force against you, an imminent use of force against you. And then how much force you can use, whether you can use only non-deadly defensive force or deadly defensive force, is a function of the intensity of the threat you're facing, whether you're facing only a non-deadly force threat or a deadly force threat, or deadly force is authorized by some other provision of law, like you're defending against a forcible felony, for example. But that's not stand your ground law. That's just self-defense law. Stand your ground law, to the extent it is a standalone law, addresses only one of the 5 elements of self-defense. And by the way, folks, I'll mention here, you may have seen this little image when I was covering the statutory language on the right here. I'll see if I can zoom this up for everybody. If you're not familiar, I guess I can't zoom it up too much. Oh, there it is. If you're not familiar with the 5 elements of self-defense, we have a totally free infographic that you can get that provides a brief description of each of those 5 elements. These are the building blocks of any claim in self-defense. If you don't understand these, you can't possibly understand use of force law. And we make that infographic available for free, totally free. In fact, I have a better image I think I can pop up. Yes, here it is. So get your essential foundation to master self-defense law. The 5 elements of self-defense law infographic available at lawofselfdefense.com/elements. It's a PDF download. We don't ask a penny for it. I urge you to download it, because if you don't understand this, you can't understand use of force law at all. If you happen to be a firearms instructor or something along those lines and would like a poster size of this infographic, that's also available. That's not free. We do have to charge for that because we have to print it and ship it, of course. But if that's of interest, you can also get that at that same URL, lawofselfdefense.com/elements. So all stand your ground does is relieve you of an otherwise existing legal duty to retreat. It removes that element of avoidance from the 5 elements of self-defense. So instead of the prosecution having 5 elements they can attack, innocence, imminence, proportionality, avoidance, and reasonableness, they only have 4 elements they can attack. That's good for you. You've been relieved of the element of avoidance. It's no longer required. It's no longer a subject of attack for a prosecutor when they are trying to negate your claim of self-defense. But all it does is remove that otherwise existing legal duty to retreat. The other four elements of a self-defense claim are still the same as they always were. And so stand your ground only helps you if you're still engaged in otherwise lawful self-defense. Other than being relieved of that legal duty to retreat, it doesn't give you any extra power or authority or privilege to use force in self-defense. Your use of force still has to meet all the other traditional requirements of self-defense. Stand your ground doesn't change any of that. All it does is remove that otherwise existing legal duty to retreat. It also specifies, this article says, that deadly force can be used when someone is in the process of unlawfully and forcibly entering a home. What they're actually talking about here is defense of highly defensible property law, the creation of a legal presumption that you're facing an imminent, unlawful, deadly force threat when you're in your home dealing with a forcible and unlawful intruder in your home. This is what that statute they're referring to here, which is 62602, always said. That was the old version of the statute. It had nothing to do with stand your ground. It just had this language for defense of highly defensible property, this legal presumption of reasonableness. And I'll show you that version of the statute in a moment. What Wyoming did when they decided they wanted to be a stand your ground state was insert into that defense of property statute the stand your ground language. And this is the kind of confusion it leads to, because now people think stand your ground, because now they refer to this new form of the statute as the stand your ground statute. Now they think stand your ground also includes this defense of highly defensible property provision. These are completely distinct legal doctrines, but because lay people are going to look at this one statute and see them packed together in one statute, they think these are related or interrelated legal doctrines. They are not. These are two different things. So Correnti goes on, purportedly quoted here, it's really a no-brainer, because in the statute it says if you're accused of reckless endangering, to look at this other stand your ground statute. Well, the reckless endangerment says if you merely pointed a gun consistent with the self-defense statute, which he's referring to as the stand your ground statute, it's just statute 62602. It says if you are accused of reckless endangering, look to this other stand your ground statute. It does say that, but only for pointing, not for discharging the weapon. The other reason he says is not only do I believe, first of all, nobody cares what you believe in court. Nobody cares what you believe. They only care what the law is. They don't care what you believe the law is. But not only do I believe in the stand your ground law, I believe the situation directly applies to the relief provided by the statute. Well, it doesn't. If he had not fired the gun, it would have. If he had merely pointed the gun and stopped there, it would have applied. Once he discharged the gun, he put himself outside the bounds of that legal provision. Correnti continues, in his motion to dismiss, Correnti also claims the fact he is both a victim, which could be true, and being prosecuted as a defendant in connection with once, presumably that should be one incident, creates a conflict of interest. I see what he's saying here. He's saying, hey, I was a victim of a crime, so normally justice would be sought for him by the local prosecutor, but I'm also being prosecuted in this case, so now he's being pursued by the prosecutor, and that's a conflict of interest. No, it's not a conflict of interest, folks. The fact that you could have been a victim and engaged in unlawful conduct does not mean you can't be prosecuted by your local prosecutor for that unlawful conduct. Again, this is simply a gross misunderstanding of how legal process and procedure works. He argues here that therefore a successful prosecution of the other guy on the pending charge of battery would make the current charge of reckless endangering by me a conflict, not only for the prosecutor, but also the state's evidence in the, well, this is all legal garbage. This is probably, presumably drafted by Correnti himself, not a lawyer, doesn't know how to write legal speak. But basically, he's arguing that, hey, only one of us could have been the bad actor. And if Nicholas Chadwick is being prosecuted for simple battery on me, and he is, then I can't be prosecuted for my conduct in that interaction because he's already been determined to be the bad actor. The prosecutor is prosecuting him. That's not how this works. That's not how any of this works. Two people in a confrontation can both be engaged in unlawful conduct. Chadwick could be on the hook for simple battery, and Correnti could be on the hook for unlawfully escalating a non-deadly force fight to a deadly force fight, and or recklessly endangering other people. By the way, Correnti could have been justified in shooting Chadwick and make that legal argument. There may be facts to support that legal argument, and still not have been justified in firing a warning shot. Just because you're justified in shooting someone attacking you doesn't mean you're privileged to start shooting rounds into the air and endangering innocent people in the process. Those are different legal risks, different legal liabilities that you're incurring. They're distinct from each other. So no, the fact that there's two parties in a fight, that one of them is charged, does not mean the other party can't be charged. The other party can be charged depending on their own discrete individual criminal liability. And then we have a couple more paragraphs here on this news story. Correnti said he's representing himself in the case to prove a point that regular people can represent themselves in court. Well, let me suggest the powerful distinction between can and should, because you can represent yourself in court. You have that legal privilege, subject to some modest constraint by the trial judge. If he decides you're a complete kook, he can make it more challenging for you to represent yourself in court. But ultimately, you have a fundamental right to represent yourself in court. You can't be obliged to have an attorney speak for you. But should you? Would I represent myself in court? As I've already spoken to, the answer is absolutely not. No question about it. So Correnti says, I believe in the judicial system. Well, I believe in it too. Like I believe in runaway trains and planes plummeting from the sky. These things happen. They exist. You can believe in them. That's different than believing you're going to get a positive outcome. The judicial system puts innocent people in prison. So you can believe in it. It doesn't mean you're going to like what you get. I believe the judicial system and the profession of lawyering have evolved to make it difficult for the average person to defend themselves. This is true. It's true. The system has made it difficult for individual people to defend themselves. That's why, because that's true, is why you don't defend yourself in court. You don't say they've made it difficult and therefore I'm going to do it anyway. Now you're knowingly doing it in an environment where you know it's been made difficult. This is not a rationale for representing yourself. The fact that it's difficult is a rationale for not defending yourself, for hiring competent legal counsel. Our Constitution says all the powers of government are inherent in the people. We need to exercise that power. Well, you do that. The way the system allows you to exercise that political power is by electing legislators and or judges or executives who appoint those judges. The application of the power is not inherent in the individual. It's delegated to political entities that purportedly derive their power from the individual, but they derive the power from the individual to themselves. You don't get to try yourself. You don't get to sentence yourself. That authority is not within you as an individual, as a defendant. Obviously, that power is bestowed to other people. We need to exercise the power. As I said, you already do. It's important to show people you can, and you need to stand up for yourself without asking other people to solve your problems. Would you do that with a root canal? Would you do your own root canal? Say, hey, listen, I got a rotten tooth, but I'll just take care of it myself. I'm not going to ask other people for help. I'll do my own root canal. Come on, folks, use some common sense. By the way, also a common theme when dealing with these kinds of individuals, in my experience, is that they often turn out to be what I would politely call poop magnets. Bad stuff happens to them all the time. Weird, just bad luck. And we all know people like this, and generally it's people who make poor life decisions repeatedly, often while thinking, or I should say, while blind to the fact that they're making poor life decisions repeatedly. What's the phrase? They're often mistaken, but never uncertain. They know they're right. And when their decisions turn out badly for them, it's never their fault. There's always an excuse. Is this guy Carenti a poop magnet? I don't know. But only 2 years ago, he was involved in another assault and battery case. He wasn't charged in that one. But in my experience, it's pretty unusual for normal people to be involved in normal adults to be involved in repeated physical confrontations with others in a short period of time. Unless, of course, it's their job, like being a law enforcement officer, for example. Carenti says, I don't believe I've ever been in trouble, but this is the first time anything has gone before a court because of the way I've conducted myself when I've been assaulted. Okay. Well, we'll see. Just because you've been assaulted doesn't mean you have a license to do whatever you want, and it certainly doesn't mean you have a license to recklessly endanger other people. So now that we know the purported facts of the story, let's take a look at the actual. It's hard to even call this a self-defense statute in Wyoming. So they call this use of force in self-defense. So it looks from the title like a self-defense statute. And here we're looking at the version of the statute that existed, that applied before July 1st, 2018. July 1st, 2018, Wyoming became a stand your ground state. They stuck stand your ground language into the statute. And now I guess some people call it their stand your ground statute. But before July 1st, 2018, this statute that's titled as if it were a self-defense statute is actually not a self-defense statute. It's a defense of highly defensible property statute. It's a defense of your home statute. And what it does is it creates special legal provisions that apply in the context of defending yourself in your home against an unlawful and forcible intruder. And these are great statutes. I like them. They effectively give you every element of self-defense you need to justify your use of deadly defensive force when you're defending against an unlawful and forcible intruder in your home. Now, you need both unlawful and forcible, because one of the concerns of the legislature is, and by the way, these legal presumption statutes exist in many, many states and almost always have the same requirement, that you're defending against an intruder who unlawfully and forcibly entered your home. And the reason you need both is because they don't want you to enjoy the benefit of this legal presumption if the person's lawfully in your home, like they're a co-dweller or they're an invited guest, for example. So it's only for people unlawfully in the home. And they need to have entered forcibly, because the legislature is concerned about the innocent intruder scenario. There are circumstances in which someone might be unlawfully in your home, but without malice. Right? So, for example, a repairman sent to the wrong address and told, hey, these people need their dishwasher repaired. They can't be home. They have to go to work, but they're going to leave the back door unlocked so you can get in, repair the dishwasher. And the repairman goes to the address and the back door is unlocked, but it's the wrong address. So he enters that home. He's there unlawfully. He's in that home, the wrong address home, without license, without permission of the homeowners. He's there unlawfully, but without malice, and he didn't break anything to get in. So there's an innocent explanation for why he's there, and the legislature does not want this legal presumption to apply to him or people like him, innocent intruders without malice. But where there might be an innocent explanation for why someone entered the home unlawfully without breaking something to get in, if they broke something to get in, there's no innocent explanation anymore. So the repairman who goes to the wrong address and the back door is locked is not going to kick in the back door so he can fix the dishwasher. Once they act with force, and by force I mean they break something to get in, then this concern about the innocent intruder goes away. Once they're an unlawful and forcible intruder, it triggers these legal presumptions. Now, the way these legal presumptions work is they have a number of conditions that have to be met. And then they have a number of exclusions that have to be avoided. So here we have the presumption. A person is presumed to have held a reasonable fear of imminent peril of death or serious bodily injury when using defensive force that's intended or likely to cause death or serious bodily injury to another if. Now, before we get to the conditions that have to be met, which we've really already talked about, look at what this gives you. You're presumed to have held a reasonable fear. So that's the element of reasonableness, one of the 5 elements. Remember, the 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. So you have a reasonable fear. That gives you the element of reasonableness. Of death or serious bodily injury. So that's proportionality. You're presumed to be facing a deadly force threat. And it's presumed that threat is imminent. So that's 3 of the 5 elements, right? Imminence, proportionality, and reasonableness. You're in your home. So even if you would have had a legal duty to retreat outside your home, the Castle Doctrine, independent of this presumption, relieves you of any legal duty to retreat, relieves you of that element of avoidance. So now you have 4 of the 5 elements. You have reasonableness, imminence, proportionality, and avoidance. The only element not included is innocence, and that's kind of baked in the cake if you're defending yourself against a forcible and unlawful intruder into your home. So basically, this presumption gives you everything. It is conditioned on the notion that the person you're defending against did unlawfully and forcibly enter your home. And you knew or had reason to believe that they entered your home. So you can't discover after the fact that they forcibly entered your home. You have to have known they forcibly entered at the time you used force against them. Normally, this would be you heard the door being kicked in or the window being broken or whatever the case may be. Then they have a number of exclusions. This presumption does not apply if the person you're using force against has a lawful right to be there. They're a co-dweller or invited guest. They're not an unlawful forcible intruder. Or that presumption, by the way, also applies to kidnapping scenarios if they're trying to remove somebody from the home. But it's not a kidnapping scenario if they have lawful custody of that person. So you don't get the benefit of this legal presumption in that case. Or if the person you're using force against is a peace officer entering the home in the performance of his lawful duties. So you don't get the legal presumption if the person you're using the force against turns out to be a police officer in the course of his normal duties. Now, you still have your normal privilege of self-defense, traditional self-defense, the 5 elements of self-defense. Even if you don't qualify for this legal presumption, you don't lose self-defense. The legal presumption is a bonus you get on top of self-defense that effectively gives you all the elements you need. It presumes they're present. If you lose the legal presumption, you don't lose self-defense. You fall back on a traditional self-defense argument. You just don't get the benefit of the legal presumption. And then it defines, what highly defensible property is in this context: a habitation, a home. It also includes temporary habitations, right? Like trailers, campers, tents. Really, it's anything you're using as your dwelling in that context of that use of force event. It would include hotel rooms, for example, while you're staying in the hotel room. So we can see the pre-July 1st, 2018 version of this statute is not really a self-defense statute. It's really a defense of highly defensible property statute. And then in July 1st of 2018, the Wyoming legislature decided to become a stand your ground state, which is a good thing. But instead of creating a separate stand your ground statute, they just inserted into this statute, this highly defensible property statute, the stand your ground provisions and some other stuff. So let's look at what they added. Post July 1st, 2018, or I should say effective July 1st, 2018, now they have a new paragraph here. And this paragraph is a rather sloppy self-defense statutory provision. It's very poorly written. If you work hard, you can find all 5 elements of self-defense in this language. But essentially, they've now put a self-defense statutory provision into what had been a highly defensible property statute. Paragraph B then begins with the legal presumption that was already in the statute, the exceptions to the legal presumption that was already in the statute, another presumption we didn't talk about but already in the statute, and then we finally get to another new paragraph. It says a person who is attacked in any place where the person is lawfully present shall not have a duty to retreat before using reasonable defensive force pursuant to Section A. That's the new Section A. That's the self-defense language, provided he is not the initial aggressor and is not engaged in illegal activity. So this is the stand your ground provision. And notice it has a number of conditions that have to be met. You have to be lawfully present, right? You have to have not been the initial aggressor, in which case you would have lost innocence, the element of innocence anyway. And you have to not be engaged in illegal activity. Now, generally speaking, you can be engaged in illegal activity and still have a privilege of self-defense, traditional 5-element self-defense. You can be a street corner drug dealer and someone attempts to commit an armed robbery of you, which happens with some frequency because Let's face it, if you're a street corner drug dealer, you have at least two things people like, drugs and money. So they're frequent victims of armed robbery. So you're a street corner drug dealer, unlawful activity, someone commits an armed robbery of you. You are generally, in most jurisdictions, privileged to act in self-defense, just as if you weren't engaged in an unlawful activity. Now, you're still on the hook for the unlawful activity, but you still have a coherent privilege of self-defense. What could happen, however, is that you lose the benefit of stand your ground. So whereas without the drug dealing activity, you would have had the benefit of stand your ground, you would have been relieved of an otherwise existing duty to retreat. Because you were engaged in unlawful activity, you lose the benefit of stand your ground. That doesn't mean you lose self-defense. It merely means you've reacquired that element of avoidance. You've reacquired that legal duty to retreat if retreat was safely possible. Then we have this weird provision that says a person who uses reasonable defensive force as defined by the new self-defense section shall not be criminally prosecuted for that use of reasonable defensive force. And these are very odd statutory provisions because basically they're saying, hey, if your use of self-defense was lawful, you won't be prosecuted. If your use of force was lawful self-defense, you won't be prosecuted. But who decides that? I mean, that's the question, right? That's fundamentally the question that's decided by being prosecuted. So it's not you get to decide that your use of force was lawful. Someone else has to make that call. And if a prosecutor decides that he can argue with a straight face in court that your use of force was not lawful self-defense, well, then you can be criminally prosecuted. And that's exactly what happens. So these kinds of statutory provisions are feel-good provisions. The legislature, because everyone imagines that, well, of course, my use of force would be lawful. So this, like what, immunizes me from criminal prosecution? No, it doesn't, folks. Because it's not up to you to decide whether or not your use of force was lawful. That's up to other people to decide. And if they decide it wasn't, off to trial you go, despite what this language says. And then we have the same defensive, highly defensible property definitions we had before, and they also added a definition of deadly force that is just the standard definition of deadly force. Force intended or likely to cause death or serious bodily injury. So now this statute, effective July 1st, 2018, includes not just the highly defensible property provisions, but also a sloppy self-defense law provision and the stand your ground provision of law, all in one statute, which really only fosters confusion, misunderstanding, especially when people now refer to this as the stand your ground statute, when that is one of what, seven major paragraphs in the statute. Only one of them is stand your ground. Every other provision addresses some other facet of use of force law. So that's where guys like Parenti get confused when they think they understand what the plain English reading of a statute is. Now, there was another, so that's the Parenti story. That's the first thing I wanted to address with all of you. The other issue that came up in the context of Kentucky defense of other law. Let me see if I can pull this provision up. Do this here. Whoops. Okay. So we had a law self-defense member contact us and say, hey, Andrew, you've said that in talking about defense of others, there's two different legal standards that can apply. And you said that Kentucky has one legal standard, and I took a CCW course, and they told me that, no, Kentucky has a different legal standard. In fact, they showed me the statutory language. So are you wrong, or are they somehow wrong? And the answer is they're wrong. Naturally, you might expect that would be my answer, but it's understandable why they got it wrong. And it's a very common error. They relied on the apparent plain English reading of a statute. And if that's all you read, that's what you would believe the law was. But the law is more than just statutes. Sources of law are more than just statutes. Now, sources of law come really from two forms. One is, of course, statutory law, as one would expect. These are bills passed by the legislature, usually debated over and argued within the legislature, passed by the legislature, typically signed by the executive, by the governor, and they become statutory law. But that's not the only source of authoritative law. The other source is case law, court-made law. And the actual law as applied, as instructed to a jury, which is really the people who apply the law, right, in the criminal context. As the law is instructed jurors, it's a combination of the statutory law and, importantly, how the courts want that statutory language interpreted and applied to real people in real cases. So the law is not what the statute appears to say. The law is not even what the legislature might have intended it to be when they pass that statutory language. Ultimately, the law is what the courts say the law is, because it's the courts who interpret and apply those statutes to real people in real cases and instruct the jurors on how that law is to be applied. The legislature does not instruct the jurors. The jurors do not simply get a copy of the statutory language. They get the jury instructions. And while the jury instructions themselves are not authoritative sources of law, they are, in effect, a combination of the statutory language and how the courts want that language applied. And sometimes how the courts want that language applied is very different than the apparent plain English reading of the statutory language itself. So in this context, we're talking about defense of others. And by the way, folks, this slide is drawn from our state-specific Kentucky use of force law course. We have a separate use of force law course for every state. So if you want to actually know what your state's use of force law actually is, to my knowledge, the most authoritative way to get that information most efficiently and cost effectively is through our law of self-defense state-specific courses. Now, these should be thought of as supplements to our advanced class. That's our 8 to 10 hours of instruction on use of force law generally, the principles that apply in all 50 states. And then we supplement that advanced class with another couple of hours of state-specific law. We have a separate course for each of the 50 states. To commemorate today's program, we do have a sale on those state-specific courses, and we do make them available independently. I mean, honestly, I would urge you to also get the advanced course, but if you want to just get the state course for your state, or if you already have the advanced course and maybe the state supplement for your home state, maybe you want a state supplement for another state, a state you vacation in, or whatever the case may be, you can get your state-specific supplement for any state you wish, any of the 50 states at a substantial discount today only. So we offer these both as immediate access online streamed courses or in DVD format, or you may have the option to get both and with an even greater discount. But you can learn more about this opportunity at lawselfdefense.com/state. It's a pretty substantial discount, and we're offering free shipping as well. But when you go to that page, you'll see there's a timer in the upper part of the page. When that timer runs to 0, this offer is over. So if you're interested in learning more about our state-specific content, you can, again, take advantage of this opportunity at lawselfdefense.com/state. And that's where content is drawn from this slide. It's from our Kentucky state-specific supplement. And what's addressed here in this section 8 of that course is defense of others. So this is not self-defense. It's coming to the defense of other people. And when you come to the defense of other people, there's 2 legal standards that can be applied. Let me see if it'll let me go to the next. So the 2 legal standards are the reasonable perception standard on the one hand, and the alter ego standard on the other. So let's imagine you turn a corner and you see 2 people fighting. Maybe it's a guy apparently attacking a woman, and she's screaming for help. She's screaming she's going to be raped or kidnapped. Both of those are deadly force offenses against which she would be privileged to use deadly defensive force herself. Defense of others law generally says that you can use force on behalf of another person to the same extent they would be privileged to use force. So you're thinking, well, she looks like she's saying she's going to be raped or kidnapped by that dude. That would privilege her to use deadly defensive force. So I'm going to use deadly defensive force on her behalf. All right, that's the scenario. So you whip out your pistol, your concealed carry pistol, you take that dude at gunpoint, say, let that woman go. And then it turns out she was not actually the victim of a rape or kidnap attempt. She was the victim of a lawful arrest by an undercover drug enforcement officer. And then we have to worry about these 2 legal standards that might apply. Reasonable perception on the one hand and alter ego on the other hand. Because under the reasonable perception standard, what controls is not whether or not you were right in your perception that she was a rape or kidnap victim. That's not required that you be right. As generally in self-defense, we're not required to make perfect decisions in self-defense. We're required to make reasonable decisions in self-defense. So if your perception of her as a kidnap rape victim was reasonable under the circumstances, well, then you could still be justified in that threat of force against someone who turned out to be a law enforcement officer. So long as you made a mistake, right? You thought he was a kidnapper or rapist. Turns out he was a cop. That was a literal mistake. But if the mistake was reasonable, that's acceptable for use of force law purposes. That's under the reasonable perception standard. You had a mistaken perception, but it was a reasonable mistake, a reasonable perception, still justified. The alter ego standard is quite different. The alter ego standard says we don't care what your reasonable perception was or how reasonable your perception might have been. We only care about what the reality was. And your privilege to use force on that woman's behalf under the alter ego standard extends no further than her privilege to use force in her own behalf. And her privilege to use force to resist a lawful arrest is 0. So that means under the alter ego standard, your privilege to use force on her behalf is 0. You have no justification under the alter ego standard. No one cares whether or not you had a reasonable perception under the alter ego standard. All they care is what the facts actually were. And if you genuinely and reasonably believed she was being the victim of a rape or kidnap attempt, but it turned out that guy was a cop making a lawful arrest, well, you're just out of luck. You have no justification. And now you're charged with assault on a law enforcement officer in the course of their duties. And that's not going away. So you can see how the legal outcome under the same facts, the application of these two different legal standards can make a big difference. Under reasonable perception, you made a mistake, but it's okay. It's forgivable as long as it was reasonable. Under alter ego, you made a mistake, you're screwed. There is no justification. You're done. No forgiveness for reasonable mistakes. So that's the issue here. And this law self-defense member contacted us and said, Andrew, you told us that Kentucky was a reasonable perception state, the more relaxed of those legal standards. But I took a CCW course, and they told me that, in fact, Kentucky was an alter ego state, the more rigorous, stricter legal standard. In fact, they showed me the statute, and the statute clearly says that, at least in the context of deadly force in defense of others, that the Kentucky statute clearly says, recites the alter ego standard. Now, for non-deadly force, Kentucky says reasonable perception. So you're good to go there. But if you're using deadly force on behalf of another person, they're requiring the alter ego standard. In other words, they're limiting you to using deadly force only if the person you're defending would actually have had the privilege to use deadly defensive force themselves. And if you look at the statutory language, that's what the statute says. So if we look at, this is Kentucky Statute 503070, protection of another. So their defense of other statute. And you see, I put in brackets, mere non-deadly force. When a statute talks about physical force and they don't define whether they mean deadly or non-deadly, what they're really talking about is non-deadly force. When they're talking about deadly force, they include some version of the phrase deadly force in there. So here the statute only says physical force. That's really just non-deadly force. So the use of mere non-deadly physical force by a defendant upon another person is justifiable when, under the circumstances as the defendant believes them to be, not as they are, not as the circumstances actually are, but under the circumstances as you reasonably believe them to be, the person you're seeking to protect would have been justified themselves in using that level of force in self-defense. So that is the reasonable perception standard. They're not holding you to the actual circumstances. They're holding you to the circumstances as you believe them to be in the context of non-deadly force in defense of another person. Reasonable perception standard for non-deadly force in defense of another person under Kentucky law. But then we proceed and we look at the portion of the statute, that same statute that talks about the use of deadly force in defense of another person. And the statute suggests alter ego. The use of deadly physical force by a defendant upon another is justifiable when, under the circumstances as they actually exist, not as you reasonably believe them to be, as they actually exist. The person you're seeking to protect would themselves have been justified in using deadly force in self-defense. This is clearly the alter ego standard. So if you're in a CCW course in Kentucky and they show you these two statutes and they tell you non-deadly force in defense of another, reasonable perception standard. Deadly force in defense of another, alter ego standard. It has to be as the circumstances actually existed. And here's the statutory language that shows that. Well, that's a pretty compelling argument, right? Except for one problem. And that is, as I said at the beginning of this segment, statutes are not the only sources of authoritative law. And as the Kentucky courts, especially the appellate courts, have applied these statutes over time, they have interpreted this particular provision to mean not what it says, not as the circumstances actually exist, but only as the defender reasonably perceives them to be. And how do we know this is how the courts in Kentucky have interpreted and applied deadly force in defense of others? Well, I could sit here and walk through a dozen appellate court decisions with you, but it's more efficient to go right to the jury instructions, which again are an amalgamation of the statutory language on the one hand and how the courts interpret and apply that statutory language on the other hand. And remember, the jury who's rendering a verdict is not given this language, not given the statutory language to apply to the facts of the case as they believe those facts have been proven or disproven. They are given the jury instructions to apply. So it's what the jury instructions say, not what the statute says, that actually reflects the law as it will be applied in a real case to real people. So here's the relevant jury instruction, the Kentucky Standardized Jury Instruction Criminal, Section 1118, protection of another. And first they address mere physical force, by which again we mean non-deadly physical force. So you can use physical force upon another to protect a third party as you believe it to be necessary. So that's the reasonable perception standard, right? Not as the facts actually are, as you believe it to be necessary. This reflects accurately the statutory language for non-deadly force in defense of another person under Kentucky law. But what about deadly force in defense of other persons? When we look at the statute said, no, as the circumstances actually exist, right? Alter ego standard. But when we look at the jury instruction for deadly force defense of another person, it says this: the privilege, including the right to use deadly physical force in defense of another, exists if the defendant believed that the victim was then or about to be, or believed there was an impending danger that the victim would use physical force upon the third party, and that it was necessary to use deadly force in order to protect the third party from death or serious physical injury or kidnapping or sexual intercourse compelled by force or threat. That's all rape, of course. But here's the key part. It's what you believed to be happening, not as the circumstances actually are. So the jury instruction for deadly physical force in defense of another is applying the reasonable perception standard, not the alter ego standard. And you wouldn't know that from reading just the statutes, because the statutes tell you the opposite of this. The statute for deadly force in defense of another under Kentucky law says, as the circumstances actually exist. But that statute does not reflect the actual law in Kentucky, because statutes are not the actual law. The actual law is how the courts interpret and apply those statutes. And the actual law is reflected in the jury instruction that the jury will receive to apply to the facts of the case. And that standard, the standard that will actually be applied, is the reasonable perception standard, despite what an apparent plain English reading of the statute would tell you. And that's why, folks, I often caution how dangerous it is to rely solely on the apparent plain English reading of a statute, because it can often mislead you. So again, one more time, if you'd like to take advantage of the state-specific course, that's the kind of content you get in these state-specific courses, folks. An accurate, law-based rendition of what use of force law is in that particular state. You can get that on discount today only. Expires at midnight tonight. Either the online streamed or the DVD format, or both, at a substantial discount and free shipping at lawofselfdefense.com/state. Let's see if there's anything else I need to see. Oh, I almost forgot to mention our sponsor. We're back to our sponsor today. Our sponsor of today's content is CCW Safe, a provider of legal service memberships. What many people mistakenly call self-defense insurance, what CCW Safe effectively does is provide their members or cover their members' legal expenses if the member is involved in a use of force event. There are a number of organizations that provide this kind of service. I'd like to think, well-informed eye, CCW Safe is by far the best fit for me, certainly personally. I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you is something only you can decide. But I would strongly encourage you, if you're interested in this kind of financial partnership, and by the way, folks, these legal expenses can become catastrophic very quickly. If you're involved in a deadly force self-defense event where you've killed your attacker and you find yourself charged with a killing charge, manslaughter, or murder, very easy to burn through $200,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family against a deadly force aggressor, it can be helpful to have this kind of financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought, which is as if the rest of your life depends on it, because it does. And that's what CCW Safe does. So whether they're the best fit for you, as they are for me, is something only you can decide. But I strongly encourage you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member with them, you can save 10% off your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. All right, let me take a look at what we have now for comments, and we'll start to wrap things up. Let's see. And again, we can only do the super chat comments, folks, because otherwise I'd be here for hours. Sorry about that. Let's see. Scrolling. Let's see. Mac Medic, thank you very much for your super chat contribution. Always greatly appreciated. Instead of a warning shot, what if he said he missed and the attacker withdrew? Well, that could be. Of course, a miss and a warning shot go to different mental states, right? Different intents. So if you fired a shot and missed, well, what could happen there? Then you would argue, well, it wasn't a warning shot. I was actually trying to hit the guy. I just had bad luck, right? I mean, even police, let's face it, what's their hit rate? And they're, in theory, professionally trained shooters for purposes of saving innocent life. As low as 25% hits, center mass hits, maybe 50% if they're exceptionally good. So misses happen all the time. It doesn't mean the miss was unlawful. In fact, if the miss was the result of a non-negligent firing of the gun, meaning you didn't do something stupid like just cover your eyes and fire it, or fire blindly around a corner, or blindly over the top of your car, or something like that, if you actually deliberately attempted to align the gun with your aggressor and fired the shot and you just happen to miss, and even if it were to strike an innocent bystander, the argument would be that you don't have liability for that innocent bystander because of the doctrine of transferred intent. So it certainly would not, also it would not be reckless, because it would have been a justified use of force. Remember, reckless conduct is unjustified conduct that involves the creation of an unjustified risk of death to others and a conscious disregard of that risk. So if the creation of the risk is real but justified, then it's not reckless because it was justified. So firing and missing is profoundly different than firing the warning shot. Also, firing and missing suggests that you were intending to hit the person. So it goes to your subjective state of mind. You at least genuinely believed it was necessary to use deadly defensive force to stop that imminent deadly force threat. Firing a warning shot does not suggest that. It suggests you didn't think it was necessary to put a round into that person. And you may not have really perceived any deadly force threat at all. You were merely trying to, I don't know, frighten off a non-deadly force aggressor by making a loud noise, impressing him with your gun. And by the way, folks, real bad guys, many of them, thoroughly unimpressed by you having a gun. not that impressed by the risk of getting shot. Really bad guys are living in communities where they all know people who've been shot, especially with handguns. And in today's world, in America at least, people who are shot with a handgun have an astonishingly high survival rate, especially if they were only shot once. If you're shot more than once, the survival rate goes down considerably. But given the state of modern medical trauma care, if someone shot once with a handgun is very likely to survive that. So they go back to their community and they become a member of the community that other people know. So everybody knows. Lots of people who've been shot and lived appear to be doing okay. In fact, the bad guy himself may well has a pretty high statistical likelihood of having been shot himself and living. So they're often thoroughly unimpressed with your gun or even the prospect that they might get shot with your gun. So if you're looking for some kind of psychological intimidation effect of the gun because of a defensive display, that can happen. And it happens quite a bit, actually. I mean, in most civilian cases of self-defense involving a firearm, the gun's not, in fact, fired. No one is shot. But I would not count on that. That's just a fortuitous outcome. You got lucky. But if you run into a really bad guy, they're not necessarily impressed by your display of a gun or a warning shot or even getting shot. You may need to compel that person's cessation of violence upon you. Berensky, thank you for your super chat. Ronnie O'Neill III did a great pro se. I'm blanking on who Ronnie O'Neill is. But so I don't know. I mean, maybe he did. The odds are against it. And we don't want that. Let's see. What else do we have? All right. Well, I think that is it for today, folks. We've been on for live for about almost an hour and a half. Thanks for coming to another Law Self-Defense live show. We'll try to do these on more or less a daily basis. Hope you all enjoy them. Again, don't forget to take advantage of the sale that's on today only for our state-specific course. Pretty substantial discount, free shipping, but that expires at midnight today. And until the next time we meet up, folks, I'll just remind all of you that if you carry a gun so that you're hard to kill, which is why I carry a gun, have every day of my adult life, I carry a gun, so I'm hard to kill, so my family is hard to kill. Well, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. All right, folks, until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.